We're here today with Michael Driggs, who is one of the trial attorneys at the Advocates, and we're going to be reading some scenarios that we've been given.
Our plaintiff was crossing the street in downtown Seattle. The defendant, who was speeding and weaving his vehicle, struck the man in the middle of the crosswalk. The defendant had a blood alcohol level greater than 0.08. The defendant did not have auto insurance. The defendant was drinking at a bar about a mile away from where the incident occurred, and there were several witnesses from the bar who told the responding officers about his erratic behavior while he was there. What a joy. This is a Dram shop case, is what it's called, and that is a case against the bar. You could sue the defendant. They would be personally responsible for the conduct. The issue there is really an issue of a practical concern. You could go and enforce a judgment against that individual and collect $0 and spend a lot of money in legal fees and get nowhere really fast. On this hypothetical, I could not tell you if there's a case or not. It seems like there's enough worth investigating, but we need to look into the conduct of the bar and what specifically they did or did not do.
The fact pattern is almost too good because you've got all the things that you need to look into. All right, how many drinks did he buy? And then have your expert look at that and decide, would he be clearly overserved? But we also have surveillance video and the cops there. And then as a practical matter, even though the defendant driver has no insurance, you're still going to want to sue them because they're going to say like he was 80% at fault and the dram shop was 20% at fault. I'm hopeful there's insurance at the bar, but they've got surveillance video.
Right, they got something going on.